Lordship.
Item 5.
Lordship.
Okay. You are appealing for
Petitioner Lordship.
your good name?
The Blue Marshal Lordship.
Your name is not in the
Lordship, yes, on behalf of Asia Lordship.
on request made on behalf of the ASO, let me counsel for petitioner. List after
2 weeks, Lordship. Much obliged.
May please, your Lordships.
Ah.
Lordship, I beg to mention item number 4. Lordship, on
Yeah.
behalf of counsel for the petitioner,
Ah.
may this matter be listed after 2 weeks, Lordship.
Why?
Lordship, here the petitioners would like to file additional affidavit, Lordship.
You have not filed yet.
Yes, Lordship. Verification is still on. The petitioners are verifying from the beneficiaries, so it may take some time, Lordship.
On request made on behalf of MS Nitu Kaza.
Yes,
You are the
Lordship.
counsel for the petitioner.
Lordship, I'm for respondent number
List the
3.
matter after. How much time you require?
Lordship, 4 weeks.
4 weeks. MS Apila Sanctum, learned counsel, appears for respond number
3,
3.
Lordship.
And Mr. LT Sanctum, learned additional AG, appears for respondents 2 and 4.
Obliged, Lordships.
Obliged, Lordship.
For motion, item number 1.
What is this?
May I please, my lord? Lordship, this IA 79 is filed for condemnation of delay of 67 days in connection with the writ appeal 17. Lordship, I have explained the delay, Lordship, in para 3, 4, and 5 of my IA, Lordship. Your Lordship will find the para 3, 4, and 5 at page 3, 4, and 5 respectively, my lord.
You have served notice?
Yes, my lord.
On whom?
On the council for the writ petitioners, Lordship, as well as to the Union of India, Your Lordship, through the CGC, my lord.
Who is the
I'm
CGC?
for respondent to Union of India.
You are
CGC.
bringing for union.
Yes.
And one, opposite party 1.
Yes, ma'am.
You have any objection? 67 days? No objection.
No.
Okay. Heard Mr. Enangami, learned government advocate, appearing on behalf of the appellants. Also heard Mr. N. Longkamer, learned counsel, appearing for the opposite party number 1. And MS.
Dezenokiso for Yangarwati. Dezenokiso.
You take
Respondent to.
You write your name and appearing on behalf of Mr. Yangawati, Leonard CGC for the respondent. Para. By this application, the applicants are praying for continuation of 67 days delay in filing the connected writ appeal. Stop. Para learned counsel for the opposite parties have no objections. Para. We have also considered the cost shown in the present application and we are satisfied. Accordingly, the delay of 67 days in filing the connected writ appeal is condoned. Registrar is directed to list the writ appeal in its usual course.
Obliged, my lord. For admission, item number 2.
Yes, additionally, you file your affidavit. When?
This morning, it was completed this morning.
Is respondent number?
Compliance affidavit. I could not find this affidavit. It's available in the file. 7.
Means.
I've gone to the affidavit, Your Lordship. So apparently what the state is also saying is that there are comprehensive instructions issued by the Ministry of Road Transport and Highways as to how highway projects, national highway projects should be built. But the fact of the matter is this has not been followed by our state or neither by the NHIDCL. That is where the whole problem arose. That's why we are in this mess right now, Your Lordship. And as far as the right of way is concerned, that is issued out, that issue is pending in the Supreme Court, as Your Lordship has already noted. And on the last occasion, Your Lordship will recall, the time for completion was 31st of May 2024. We are past that date right now. So what is the NHIDCL going to do? What is the contractor going to do? It is for them to answer now, Your Lordship.
Is there any timeline?
31st of May 2024.
2024.
Yes.
May.
An affidavit has been filed by the contractor this morning, and the percentage is 73.55%.
Yes.
Physical progress.
Respondent 9.
Please, your lordships. My lords, as far as the extension of the period of contract is concerned, that is also pending before the Honorable Supreme Court. And the matter is fixed on 30th of July,
But you have
2024.
already made a commitment before this court that you will complete it by 31st of May, isn't it?
My lord, under such pressure to finish the work, we have also been.
Why did you make the
Yes.
commitment?
Your lordship, because the original contractual term, extension is, actually it lies with the NHIDCL and the contractor. But the honorable court is also, since this is a public interest litigation, under the pressure of the public.
When was
No.
the commitment made that 31st?
Your Lordship, it was an extension which was granted to them by the NHIDCL.
Hmm.
And on that basis, it was placed before the Honorable Court. That was by way of an affidavit, Your Lordship.
Where is that affidavit?
the affidavit of the respondent number 9 filed on 7/2/24. 7/2/24 at paragraph 4. 7/2/24, affidavit filed on 7/2/24 at paragraph 4.
Yes,
Have the Lordships got it?
yes.
That for the appreciation and perusal of this honorable court, respondent number 8 by letter dated 2nd February 2024 has approved the extension of scheduled completion date by 770 days up to 31/5/24. And the extension is at page 10. Annexure, which is at page 10. Page 10 to the affidavit.
Yeah, who appears for the NHIDC?
My lord, before the NHIDCL gives the reply, if my lords may kindly appreciate, the 73% is including the 2 kilometers road starting from Kohima that was handed over to us in the month of April this year. But we have not accepted that because of the timelines, all these issues put together. If we accept that, then again, we'll be running behind the schedule. And that road that has been handed over to us is up to 3 layers.
So that this 73% completion
It
is
should,
minus the 2 kilometers.
no, the percentage is inclusive of the 2 kilometers, but the 2 kilometers which was under maintenance by the PWD, the Nagaland PWD, your lordship, if we exclude that, if that is taken away from our work plan, then the percentage will be more than 80%. I have asked from the engineers of my client to give me a specific percentage, but they could not give me that. So my sincere apologies that I could not bring the exact percentage of the finished work. And as far as the finished work, 100% complete is concerned, my lord will see at my affidavit that I filed this morning at page 6. As far as the carriageway of the vehicle is concerned, your lordship, there is no more problem with the present road. Page 6 is annexure 1. Up to 3 layers, we have completed 100%, your lordship.
Which one is that?
Serial number 1, that is EW up to subgrade top, work done 100%. 2 GSB, work done 100%. 3 WMM 100%. So as far as the carriageway is concerned, there is no more problem with the vehicles. But if my lords may kindly appreciate, I have a specific instruction from my client to request this honorable court to place on record a hurdle that is going to be a huge problem for the commuters in the future. If we finish the BC at serial number 5, BC serial number 5, which is now 33%, your lordship. If we finish this, there are in several chainages, there's a major problem that the moment we finish the final BC, the carpeting, the road width will become again smaller. And with a good road, there is likelihood that this road is going to become an accident-prone road. So the chainages where we need road shoulders and some few meters of the road, if it can be placed on record, and if the landowners, instead of strongly claiming the compensation, if for safety measure, that we will need the help of the administration also, where if they can give us a little more.
Have you seen the affidavit filed by the state this morning?
Yeah, I've just gone through, your lordship, but for the safety of the commuters, life is bigger than the compensation issues, which I hope with the help of the state will be able to get at least 1-2 meters in some areas. If not, it's going to become a very dangerous road, your lordship. So we have to finish the work that is there, your lordship. And as far as the carriageway is concerned, no more problem is there. Carriageway, we have finished 100% up to 3 layers. So no problem with the vehicle, but we'd also like to place on record, it's a specific request for my client to place this before the zoning court so that the drainage areas where we may require at least 1-2 meters for the
That
safety of the
means state
commuters.
government comes forward, this court cannot say much.
My lord, your lordship, do I have the permission to place on record in affidavit so that we may have to approach the authorities also to see that?
Whatever this, that is up to you.
My lord.
Yes, NHS. What do you say on the affidavit filed by the respondent? It's only 73%. Time, the time limit given by you is 31st of May.
Yes, Lordship, which has lapsed, Lordship.
Yeah.
And Lordship, since the matter is pending before the apex court, Lordship, at the moment we cannot take any decision because the matter is coming up on 30th of July, 2024, Lordship. Till such time, we cannot take any decision, Lordship. Otherwise, the fact remains that the timeline has lapsed, Lordship, on 31st of May.
What is there in the Supreme Court?
Your Lordship, when this honorable court took up the PIL, the concern was that the existing road should be made pliable so that the commuters would not be hindered in traveling on the road. And the acquisition process was directed to be taken up side by side. What happened was that the NHIDCL was insisting on certain parameters to be followed and timelines to be met, because of which the contractor went to the Supreme Court saying that unless the right of way is provided, he cannot meet the timelines. So that is the issue before the Supreme Court, Your Lordship. And because of that, Your Lordship would recall the order passed by Your Lordship where the timeline was given, unless he meets that timeline, he'll be blacklisted.
Which order was that?
This is the order dated 13/3/23. 13/3/23. Has Your Lordship got it? 13/3/23.
Order.
Yes. (13/3/23).
Yes.
Yes, if you can come to the paragraph which starts with the last part, we therefore pass the following orders. A, NHIDCL shall not deduct 25% from the bill submitted by the contractor, respondent number 9, citing non-achievement of width as per the TCS. No demand for TCS will be made by the NHIDCL to the contractor, and the work will be executed on the existing order. TCS means typical cross sections, so specifications. Any bill submitted by the contractor shall be paid as expeditiously as possible after joint verification by both parties. C, the contractor, respondent number 9, is directed to complete the NH2 on the existing road from Kohima to Mao on or before 30/5/2023 without compromising on the quality of work. D, failure on the part of the contractor to complete the work as directed here and above, costs shall be imposed upon the respondent number 9, and NHIDCL shall be directed to issue show cause notice to the respondent number 9 contractor for blacklisting. E, we also direct the NHIDCL as well as the contractor concerned to file their respective affidavits on the progress of the work before 12/4/23. We also request the learned amicus curiae to have an inspection of the work before the next returnable date and file an affidavit before 12/4/23. So they went to the contractor went to the Supreme Court, and by an order dated 12/5/23.
Clause D has been stated.
Yes, clause D has been stated.
12.
12/5/23.
Clause D has been stated.
So effectively, clause D and clause C also have been stated by virtue of D. Your Lordship, I think if I may. if I
Yes,
may
Mr.
suggest.
What do you say, Mr. Zuma?
My lords, since the matter is pending before the Supreme Court, our hands are tied here. It would appear so, my lords,
It's coming up on 30th
or 30th July.
July.
So perhaps we can list the case after that.
That's what's happening, that's the problem.
Yes, my lords. In the meantime, what the NHAD cell and the contractor can do as far as the execution of the project is concerned. And also the issue of the right of way, which is still a live issue. Now, the state has filed an affidavit saying that there are clear instructions from the MORTH. And National Highway being a central subject, this is something which the state also has to follow and the NHAD also has to follow. They have not followed it right from the very first instance. That's why we are in this mess.
Your Lordship, in most places, we cannot put road signs also because it requires some space where for the commuters, for safety, we need to put up road signs. There's no space to put road signs also, Your Lordship. That problem is also being faced. Safety is a major concern in this road, Your Lordship. Besides the work execution that we also have to finish as early as possible.
So you want to file an affidavit?
Your Lordship, we want to show the changes where without extension, the moment we finish the final carpeting, the road goes up and the width becomes smaller. Accident, Your Lordship, life concern is becoming one major concern again for the contractor also. So we want to point out the changes where something need to be done. If not, at the end of the day, all the parties will be at fault.
So that is primarily between the contractor and NHADCL and the state. And the state.
We may be allowed
We
to
can,
place
your
it on
worships can leave it
record.
open to the contractor, the NHADCL and the state to take up these issues.
But if we point out the changes, the exact locations, that may also be helpful for the zoning board as per the instructions of my clients, Your Lordship.
Okay, heard Mr. A. Zimami, Leonard Amicus Curie, as well as the Leonard councils appearing on behalf of all the respondents. Stop. The state respondents, particularly the respond number 6, has filed an affidavit. Bringing on record the, where's that document?
Lecture one.
No, not the next one. Where's that after?
Comprehensive guideline, that is under, lecture one. Your Worship. Starting from page 8 of our affidavit.
Bring on record the communication dated 11 July 2023, written by the Secretary, Ministry of Road, Transport and Highways, and addressed to the Chief Secretary, Government of Nagaland. And the relevant portion, which is under page 43. 8A. Stop. Para. The respondent number 9 has also filed an affidavit. Wherein it is indicated that the physical progress of the road, of the construction of the road, as on 18/6/2024, is 73.55%. Stop. Learned Council appearing for respond number 9, however, submits that the said 73%, however, submits that if the, what is this BC?
Bituminous concrete.
Yes,
That's the last layer.
If the,
your lordship.
what is it?
Bituminous concrete, your lordship.
Are we sure?
Yes, your lordship. It's also, in a layman's term, it's known as carpeting, so your lordship. I got
That
mixed
the
up.
bituminous carpet, within bracket carpeting of
Bituminous
the
concrete.
bituminous concrete, within bracket carpeting, is carried out over the stretch of the NH2, isn't it?
Yes.
Yes, madam.
NH2, it may create certain, it may create an accident prone area
In certain areas.
in certain areas. And therefore, he prays for filing an affidavit, bringing on record
My lord.
such areas where the accident may occur after the BC is completed.
My lord.
Stop. The prayer for filing the affidavit by the respondent number 9 is allowed.
Lordship.
Stop. List the matter. When do you want? After 4 weeks?
After 4 weeks.
List the matter after 4 weeks.
My lord.
Or maybe after 30th July, my lords? After 30th July?
Yeah, we'll keep it 4 weeks. Let's see what happens.
Very well.
My lord.
Much more.
Bless your lordships.
For admission, item number 3.
Yes.
Please, your lordship. Lordship, we have received the affidavit filed by the state respondents.
This
As
morning?
per the, yesterday. As per the
What-
last
what
order,
affidavit?
lordship,
When was the
the,
affidavit filed?
May I please your lordships?
Oh.
I'm appearing for respondent number 2, 3, and 4. By order dated 12/6/2024, the respondents were directed to file additional affidavit as to whether the nodal department has designated the sanctioning authority.
Huh.
Only that was a limited direction. So accordingly, I filed my affidavit, which
Who's
is
the sanctioner authority?
Director of the Social Welfare Department, lordship.
Okay.
Lordship, page number 8, if I may be allowed to read, lordship. Page number 8 of my affidavit.
Yes.
Paragraph 5, point number 5 of the page number 8, submission of application. The application for grant of pension to eligible and deserving person may be submitted to the concerned district welfare officer in the prescribed format after allowing all procedures outlined in Rule 6 of the National Nagaland Social Security Rules 1998. Now, particularly on 7, the sanctioning authority, that is the director, shall have the right to stop payment of pension if at any stage it is found that it was sanctioned on a mistaken ground or false information. The decision of the director shall be final, lordship. So the director has been designated as a sanctioning authority, lordship.
No, is there a designation order? One order has to be issued, isn't it?
Lordship, we follow the Nagaland Social Security rules, Lordship.
Hmm.
Lordship,
So on
if I
the
may
basis
allow-
of the rules,
Lordship.
no specific order is
No,
required
no,
to be.
no, Lordship. If I may be allowed to place on record, Lordship.
Yes.
Lordship, page number 2, I have put it as flag 1. Rule 3, clause, subclause 6, Lordship. Sanctioning authority means the Director of Social Security and Welfare, Lordship. So as per the rules, accordingly, we have also put on in the payment book for the old age pension scheme also, Lordship. So we follow this also on. Lordship.
Lordship, my humble prayer is that this matter can be closed, Lordship, with directions. Lordship, may kindly, Lordship, I want to point out one issue here, Lordship. The affidavit which the respondents have filed,
Which
they have
affidavit?
provided a list, Lordship.
Which affidavit?
Affidavit
11 June? 11th of June?
Lordship, we received on 14th of June.
Whatever it is.
Yes, so this could be the affidavit, Lordship. The relevant paragraph is in page number 3,
Page number?
page number 4,
Uh,
3 and 4, Lordship, para number 3 and 4, Lordship. So, Lordship, here the petitioners, with the direction of this honorable court, had submitted a list with the help of Pro Bono Club, Kohima College, Law College. Now, Lordship, the list provided is reflected in order 14-9 of 2022.
Are we on the same affidavit?
Lordship, the affidavit where the respondents have provided the,
Now, how does it begin, the cost title? In the matter of order dated 5/6/24, is it like that? First page?
5/6/2024, Lordship.
Is this-
order dated 14-9/2022.
No,
This
then-
is filed in compliance of this order.
Then we're seeing the wrong affidavit. Order dated,
In compliance of order dated 14-9/2022.
this is the one. 14 June.
14 June 2023 affidavit.
Yes, Lordship.
Uh.
So, Lordship, here the petitioners had submitted the list. That is 198, containing the list who are eligible. That is 198 persons.
Page?
Now, through this affidavit, the respondents have filed, have maintained in page number 4 and 5, Lordship. Para number 3 and 4.
Page number?
Page number 3,
4.
page number, it starts from page number 3, Lordship, para number 3.
Page number 3.
Yes, my lord.
Yes, para number?
Para number 3.
Hmm.
Para number 3, 4. 3 and 4, Lordship.
What do you want to say?
So, Lordship, the list provided by the petitioners through this affidavit, they have complied by maintaining that out of 198 list provided by the petitioners, out of 198, Lordship, 136 are not availing.
60
my
are
apologies,
availing,
Lordship.
60 are availing, 136 are not availing.
62 are availing, 136 are not availing, Lordship. So here, my only prayer is that these people who are eligible, Lordship, if their case can be considered, Lordship. Because as per the ceiling as per the
No, but
benchmark,
have
Lordship.
you seen the affidavit filed by the, filed on, 11th of June, 2024? Do you have a copy of that affidavit?
Yes, my lord, I have. Now here, Lordship, in annexure 3,
In this 11 June affidavit?
yes,
Yes,
my lord, here in the annexure 3, the union has provided a benchmark, Lordship, which is in page number 15. State union territory wise ceiling of beneficiaries under
Correct.
NSAP.
Correct.
Lordship, in serial number 26, Lordship,
Yes, Nagaland.
Nagaland has been provided. Now under National Old Age Pension Scheme, there's a benchmark of 45,941. Lordship.
Yes.
So now the old age pension people who are availing, now the list provided by the petitioners and the list submitted for proposal, it doesn't reach the benchmark, Lordship. So their case can be considered, Lordship.
That's what you have written a letter, isn't it?
Lordship,
Who is
Lordship.
that letter?
Lordship,
Annexure 2, isn't it?
Lordship, annexure 2, page number 8 of my affidavit, Lordship. We have categorically stated of the 82. Lordship, here by the Pro Bono Club, they have identified 198. So accordingly, the department also re-verified it again. On re-verification, we found out that 60 were availing, Lordship. 60 were availing, one was already expired, one was a retired government. So we have strike off, Lordship. And out of that 198, 144 persons were included, Lordship, in those in strike off and all those death due to death and all. We've included 44% already from that 198, and 10% were replaced in date replacement. And now the remaining out of 198 is 82 only, Lordship, which we have categorically stated in our affidavit and communicated to the ministry, Lordship.
Is the union a party here?
Lordship.
Yes, my lord.
You are appealing for this ministry?
They have,
Have you seen the annexure 2, page 8 of the affidavit of 11 June
they have
2024?
implemented the rural department. Earlier, they have implemented this Ministry of Social Justice. But, so they were directed to implement the rural department, and they have already implemented, I think. But
Are you appealing for the rural development?
I have not been served a copy of the petition, the request petition. So I have not taken steps.
No, I think everything is. No, it's still not.
But I have not served a copy to the ministry. They don't know whether it is.
Have you served a copy?
Lordship, earlier,
They have not served the request copy.
earlier we,
Implementing the new.
Lordship, the petition is same. The
No,
petition
petition
is
is,
same.
there's
Yes,
no,
yes.
no recast, it was just a recast cost title.
Yes, Lordship. Lordship, the only thing that remains here is that
No, no.
82%.
That is
Lordship.
fine.
Yes,
Now, I think things are set in motion
yes, Lordship.
insofar as the implementation is concerned. Now, the state government has written in the month of June 2023.
Yes,
It
Lordship.
is it's about more than a year now.
Lordship, Lordship.
Now, we want to know whether this rural development from the ministry is going to sanction the amount that you have requested.
Lordship, by order, in my affidavit, page number 13, the Ministry of Rural Development has wrote back to the Secretary Department of Social Welfare, Lordship, page number 13 of my affidavit. affidavit dated 11 June. 11 June. Here, page number 13. The
Para two.
Yes, my lord.
lordship, para 2 lordship. So accordingly, the department has again started doing the verification and slowly the inclusion is going on, lordship. So 82 is on the priority and remaining 1,000 to 17,160.
No, this is not a conclusive reply, isn't it?
Lordship.
It is not a conclusive.
Lordship, but since the ceiling is there by the ministry, the state also cannot go beyond the ceiling,
No,
lordship.
no, we are not saying that you should go beyond. the
Lordship,
ceiling.
lordship,
We are very much below the ceiling.
lordship.
Yes,
lordship.
my lord.
So you're just requesting for 82 plus only
17,000.
17,000.
Lordship,
what,
137
beneficiaries are there.
lordship.
So another 82.
Lordship.
So you requested by 8th of June 2023. And state government is also supposed to contribute a matching contribution.
Lordship,
Are you doing that?
lordship. 100 rupees in 60 to 79, addition to the 200 rupees being sanctioned by the ministry, and 500, 100 to the 80 and above age, addition to the 500 being sanctioned by the ministry, lordship.
Okay.
So lordship, by humble submission, lordship, at this stage, the action may be given, lordship, to accordingly follow by the guidelines and accordingly include the beneficiary lordships.
Remaining beneficiaries.
Yes,
Remaining beneficiaries, lordship.
CGC.
Since letter has already been written by the ministry, Lordship.
Have you seen this letter?
Yes.
Okay, we'll discuss.
Lordship. Obliged, lordship.
Obliged, my lord.
For admission, item number 6.
What is this?
Please, your lordship. Lordship, I'm for the petitioner. Lordship, the respondent number 1, 2, and 3 has already filed their affidavit in opposition. Your lordship. So if you can hear the matter today.
You want to hear today?
Yes, my lord. Let the matter be taken up after part 1 matter, my lord.
Pledge.
For admission, item number 7 and 8.
May I please, your lordships? Your lordships, due to non-return of service report by order dated 22/5/2024, this court has directed the appellant to issue fresh notice through dusty service. However, the same has been, the respondent one, who is the main respondent, has refused to accept the dusty service.
Okay. My brother cannot take up this.
Yes, Lord.
List this case before any other bench without one of us. Within bracket, you put Justice Nelson said.
Obliged, your lordships.
For orders, item number 9.
My lord, I'm appearing on behalf of S. Mayor.
Who's for the appellant? Who's for the appellant?
Here in the cost list, it is written Z. Khalid. Khalid, yes.
Last time also he did not appear.
Can you direct or tracking of the posting? So just waiting. They can track, I think within 3 months they can track. Okay. Yeah, those two, okay. That's within 3 months. Time is still there.
None appears for the applicant. The issue is directed to to
Track the
track the
notice.
notice sent to the respondent number 2. And put up a note to that effect. List after 2 weeks.
Much obliged.
For orders, item numbers 10 and 11.
Also, I-56 is for condemnation of delay, Lord.
There was a mention in the morning. We did not permit a mention.
Lord.
Who was mentioning?
It's me, my lord.
You are for the
Private respondent 17.
17. You are entering appearance for first time?
Yes, my lord.
This is notice is awaited, but he's appearing.
This one can be complete, the rest is still awaited. Should track this also, I think. Probably.
Yes, what do you want?
My lord, may kindly list this matter after 1 week.
Why?
The main counsel, he is not in position, he didn't turn up today. I'm a proxy counsel appearing on behalf of Takakichu.
Okay. Heard Ms. Mua Jamil and the council for the petition. We have perused the office note dated 14/6/2024. Stop. Registry is directed to track the what was it? The postal receipt, isn't it, of the respondents 18, 20, 21, 24, 25, 26, 28 to 32, 34, 35, 38 to 45, 47, 48, and 50 to 54. And after, put up a note to that effect. Stop. Your good time, please.
Sorry?
Your name?
My name, please. J. Newman. J. Newman. I have
Mr.
given.
J. Newman, Learned Council. Appearing on behalf of Mr. Takakichu,
Right.
Learned Council, enters appearance on behalf of respondent number 17. Stop, list the matter after 2 weeks.
For admission, item number 6.
Please, your lordship. Please, your lordship.
Yes.
Your lordship, this writ petition pertains to a habeas corpus case, your lordship. Your lordship, this detention order has been passed while the detainee was in custody, your lordship. Your lordship, I'm challenging this impugned detention order dated 4th of July 2023, passed by the Special Secretary Government of Nagaland in exercise of the power conferred under subsection 1, section 3 of the Prevention of Illicit Traffic in Narcotic, Drugs and Psychotropic Substances Act 1988, in short, PIT and DBS Act, your lordship. Initially, the detention was for three months, your lordship. It was with effect from 4th of July 2023 till 3rd of October 2023. Your lordship, the detention order is at page number 27, annexure D, your lordship.
Yes.
Your lordship, thereafter, subsequently, the Chief Secretary to the Government of Nagaland, in exercise of the power conferred under section 9 of the PIT and DPS Act, confirmed the impugned detention order dated 04 July 2023, with confirmation order dated 29 September 2023, for another period of 3 months, with effect from 4th October 2023 till 3rd of January 2024.
Where's that? Where's that?
The confirmation order is at page number 29, your lordship, annexure F. Your lordship, thereafter, the detainee have filed a representation through the jailer on 1st of November 2023. However, the same was rejected on 7th of November 2023 by the Special Secretary to the Government of Nagaland and the Chief Secretary on 17 November 2023. Rejection is at page number 39 and 40, your lordship, annexure H and I. Your lordship, following the rejection of the representation, the Chief Secretary to the Government of Nagaland in exercise of the power under section 9F of the PID and DPS Act further extend the detention order, wide order dated 19 December 2023 for another period of 3 months, with effect from 4th of January 2024 till 3rd April 2023, which is at page number 41, annexure J, your lordship. Your lordship, thereafter, the petitioner filed a writ petition criminal 02/2024 before this honorable court. However, your lordship, during the pendency of this proceeding, respondent number 1, wide order dated 1st of April 2024, further extend the detention of the detainee for another 3 months, with effect from 4th April 2024 till 3rd of July 2024. As such, since the petition has become infructuous, your lordship, the petition has withdrawn the writ petition criminal 02 of 24 with the liberty to file afresh, your lordship. Your lordship, coming to my ground of challenging impugned order, your lordship.
Let us see the act.
What is the relevant provision?
Section 3, your lordship. Clause 3, section 3, clause 3.
No, what is the name of the act?
PIT and DPS Act, Prevention of Illicit Traffic in Narcotic, Drugs and Psychotropic Substances, Act 1988.
Sure.
See? Grievances
104, your lordship.
122.
Same book.
Yes, your lordship.
Section 3.
Section 3, clause 3, your lordship. Your lordship, may I read, your lordship?
Just a minute. I have not got the each number.
Lordship, page number 104.
So, 122.
Your book and our book is not similar.
Okay, your lordship.
Pagination is not similar. That's why.
Okay. May I read, your lordship?
Yes.
Your lordship, section 3, power to make orders detaining certain person. Clause 3, your lordship. For the purpose of clause 5 of Article 22 of the Constitution, the communication to a person detained in pursuance of a detention order of the grounds on which the order has been made shall be made as soon as may be after the detention, but ordinarily not later than 5 days, and in exceptional circumstances and for reasons to be recorded in writing, not later than 15 days from the date of detention, your lordship. Your lordship,
One minute, 1 minute. You were first detained on
4th of July 2023. The detention was passed on 4th of July 2023.
and when was communication made to you?
Communication was made on 15th of July 2023, your lordship. Your lordship, section 3, clause 3 is very clear, your lordship. It says that the order shall be made as soon as may be after the detention, but not ordinarily not later than 5 days. And in exceptional circumstances, for the reason to be recorded in writing, not later than 15 days from the date of detention, it says. No record in writing has been given to me at the time of furnishing the detention order.
It's not necessary it should be given to you, but you should have, do you have the records?
Yes, my lord.
You have the records.
Yes.
So the communication was made after 5 days.
After a lapse of 11 days, your lordship.
After
Yes.
5 days.
It should be within 5 days, but it was served only on 15/7. So, my lord, the reason is there was road blockage between the Kuki Dolong to Dimapur, that area. That is why we could not serve on time.
Have you recorded that?
In the affidavit, we have stated.
Your lordship, only in the.
We want to see the records. Have you made that recording that you have communicated it beyond after 5 days?
Yes.
For this, for so and so reason.
Only says that within 5 days. In fact, in exceptional cases, by recording reasons, 50 days. Which has been recorded. First time I've come across this. That was Preventive Detention Act. Similar.
You have not gone through the records.
My lord, yes.
For what reason are you holding the records?
My lord, it is not recorded.
Are you sure?
Yes.
But you have stated in your affidavit.
Affidavit, yes, because I've received the instruction.
There is no source of that information in the affidavit
the record should say something, then only you file the affidavit according to the records. You cannot improve by way of affidavit.
What have you stated in your affidavit?
Affidavit that due to the road blockage.
Is that reported in your?
Yes, in the affidavit I have stated.
We are not asking you about the affidavit. We are asking you about the records. Who issued the detention order? Special secretary?
Yes, Your Lordship.
Did the special secretary make a record? Record in writing that for this so and so reasons, the detainee could not be communicated with the detention order within 5 days. You can check up this report. You check up the reports and come back.
5 minutes, my lord. Kindly give me 5 minutes.
Okay. Sometime. Yeah.
For hearing item numbers 12 and 13.
Learned Aegis.
Hello.
Yes. Maybe you'll have to start afresh because AG is appearing only today.
Your Lordship.
Then you start first. More, have you instructed the AG
Your Worship.
about what
Yes,
we were discussing the other day?
Yes.
Okay. Learned AG, are you aware what happened the other day?
Well, I have seen the order passed on the last day,
Hmm.
and I have received some papers also in this context.
Hmm.
So if my learned friend wants to give a brief introduction, just to, so that I can recapitulate exactly what happened. But if I were to make a submission, then I think let him start first so that I can give it my viewpoints. That would be better, unless you would also want to give first.
The one ground taken by the senior counsel applying for the revision is that chapter 4A of the rules of 1937 has not been made applicable in the state of Nagaland. And in the absence of the applicability of chapter 4A, the issue of having a tribal court, correct, Iralo?
Yes.
Having a
Right.
creation of a tribal court does not arise.
In fact, my lord, in this context, incidentally, not because of this case, we have been examining certain issues pertaining to the customary courts. Including chapter 4A, the various rules, rule 40, 42, 44, rule 60 and the like. No doubt. Some of the constitution of the court, some of the notifications, etc., is a little hazy. Now, even in the matter of separation of judiciary and executive, one of the reasons we sought time was we are structuring this entire exercise. The government does not want to enter into any adversarial litigation in this, because the independence and supremacy of the customary courts, customary practices, as enshrined in Article 371A, has to be protected. Notwithstanding the same, we find the three types of courts, the village court as they call it, then the subordinate customary court, then the district customary court. So if at all certain changes are made as far as chapter 4A is concerned, I'm seeing it not just with the reference to this particular case, because this is very important and very significant as far as the state is concerned. And I am obliged to this extent that notice has been issued to me so that I could also put a little bit of my inputs in this. So if you see the different three tiers of the court, like village court, presuming that we make changes in chapter 4A, the question would be, you have on one side the additional district judge, the district judge, then the high court, whereas customary courts, the appeal lies as far as the subordinate customary courts are concerned to the district customary court.
Give me the rules, 1957.
This is there in rule 40, 42, and 44. Rule 40 is the constitution of the village court, giving all the details. Likewise, is the rule 42, dealing with the subordinate district customary court. And finally, rule 44, dealing with the district customary court.
No, that's fine. The only thing is, 4A is not yet
I'm aware of that.
applicable. Then how?
I am aware of
it. How do we?
I am aware of that. That issue, I'm clearly aware of it. And these issues we have been discussing of late, not because of this case at all. And when I said that we'll take a little time as far as those judicial officers are concerned, this was the only stumbling block. Now, the government has already taken a decision to bring the customary courts in its right perspective as was conceived. Because during my recent interaction, a question was posed to me, where are the customary courts? Now, those customary courts have to be placed in the right place. Once that is done, only then the question of where the appeal will lie can be decided. Because if you have a two-tier court like the village court and the subordinate district court and the district customary court, whether it should still go again to another forum of a district judge or whether it will go directly to the High Court. These are questions which are being examined. So in the light of that, there's no qualms on chapter 4A as far as the customary courts is concerned. No qualms at all. Then as far as the nomenclature change which took place in 2008 is concerned, that is also established fact. As far as the question as to from where the powers are derived, these things are all being looked into by the government. And I don't want to fritter it away by not providing proper assistance to this court. Therefore, we are in the process of examining all these facts, which will require a little time. And I am personally involved in this issue. So that we had the same problem even in Supreme Court. In one of the pending litigations, one of the parties said that we have a customary practice like this. Court asked them to produce the customary practice. There was no customary practice in that. So different routes were given by the court to proceed ahead with the case. To see that we arrive at some solution because it involves different tribes, different practices. And to also ensure that some type of rationality is instituted by a type of consigning these courts in the right place. This exercise is being done and it should have been done long back, no doubt about it. We also see that when people talk of customary court and we want customary law, all these things, because of the fact that we don't have the script, it is passed on from generation to generation. That also creates difficulties. It will be the oral testimony of senior people which will prevail. Though my learned friend may give a brief introduction to the matter, which is welcome. But as far as the state is concerned, we are examining this point. We are not adversarial at all. So that we can get a.
Sorry for interruption, but Your Lordship, the issue here is not about the customary laws, about the setting up of customary laws. It is purely within the jurisdiction of the state. How to go about the customary laws provided under chapter 4A. That is, we are not dealing with that issue in this petition. Now the issue in the present case arose because of the decisions rendered in the case of Registrar General of Gauhati High Court. Now, this deals with the separation of the judiciary from the executive. And if we are to follow the principles laid down in this case, Registrar General's case, then the state of Arunachal has already been, the rules of Arunachal Pradesh has already been repealed by implication. And for that purpose, Your Lordship, let me take Your Lordships to paragraph 15 of the judgment in the case of Registrar General. Your Lordship will see in the enclosure 3, which I have submitted last time, enclosure 3.
Have you furnished a copy of this to the Advocate General?
Yes, Lordship.
Have you got the copy of the enclosures? Learned AG?
We have got some of the things mentioned in the annexures, not these things as such. But that's no difficulty. I have access to this.
Judgment, paragraph number 15. I'd like to start from here. May I read, Your Lordship? Paragraph 15.
Yes.
Thus, administration of justice by regularly constituted courts manned by judicial officers of the cadre will function as per the Civil Courts Act, and to that extent, the Northeast Frontier Administration and Justice Regulations 1945 conferring judicial powers on the executive will cease to operate. The doctrine of implied repeal will apply. Then paragraph 17. We now take up the case of Nagaland. The Nagaland Judicial Service Rules 2006 have been promulgated and almost simultaneously with the Arunachal Pradesh Judicial Service Rules, and judicial officers have since been appointed to man the court. The Civil Courts Act has to be held applicable to the state of Nagaland also on the same analogy. If we are to follow the same analogy as conferred to the Arunachal Pradesh, then our rule also has already been repealed by implication. Now, by repealing the rules, it does not take away the provisions of the Constitution or customary laws. Even by this judgment itself, it has been saved. It has been saved. Now the question is, since the Ganburas, the chief headbands and village authorities exercises powers of adjudication, civil adjudication, not as a customary court, but as a civil court, because Rule 24 has clearly spelled that one. Rule 24 of the rules. May I read the Lordship? Rule 24, page 28 in this blue book.
Yes.
Mausadars, Ganburas, chiefs, headmen of Khels, Dubashis, this subsequently amended, or other village authorities sitting with the village elders in council are empowered to try cases without limit as to amount, but with the following reservations. They may not try suits in which a native of the plains or native of another village not resident in their jurisdiction is a party. So this is not a customary court, as presumed wrongly by many. This is not a customary court. Now these lowest levels in the village, Mausadars, Ganburas, they can try any civil suits without limit as to the pecuniary jurisdiction. So this is a civil court. This is a civil court. But now the question is, since the rule has been repealed in terms of this Registrar General's case, and by this judgment, the customary practices have already been protected under 371A. Now, where do the aggrieved party approach in appeal? And because in the earlier judgment, His Lordship's Justice Serto's judgment, from which this reference has been made, His Lordship is of the opinion that since this has nothing to do with customary practices or customary laws, appeal will lie to the district judge. That is the view of His Lordship Serto. Otherwise, since the rule has been repealed by implication, following the analogy as rendered in the case of Arunachal Pradesh, our rules goes. Then now, where do we go in appeal or revision? Because Rule 31 is already gone. Because the rule has already been repealed. And therefore, the view rendered by His Lordship Justice Serto in allowing an aggrieved party approaching the district judge or additional district judge in civil matters, there is no bar. There cannot be any bar because under a repeal Rule 31, we cannot file appeal. This is a peculiar circumstances. Now, in the case of Registrar General, now problem has been created because it was under the impression that there is a customary court already in existence. Same was the view of the learned judge who made the difference, who made the reference. And in that, he quoted chapter 4A as if chapter 4A is in force. Now, admittedly, as also agreed by learned AG, this chapter 4A has not been enforced. Despite that, the usages or customary laws has been protected by the decision of this general registrar's case. Because in the last part of the judgment, we may start from 32, paragraph 32. It is thus clear that if legislative intent is to bar applicability of CPC and CRPC to customary courts and courts manned by executive officers, the said bar cannot be held to be applicable to regular courts. This interpretation will be harmonious with the functioning of regular courts and courts under the Civil Courts Act and also customary or executive courts under the Administration of Justice rules. Accordingly, we hold that the Bengal Agra and Assam Civil Courts Act 1887 is applicable to the district of Dima Hasao and Karbi Anglong in the state of Assam and the state of Arunachal Pradesh and Nagaland. The administration of justice rules applicable in the state of Nagaland and the Northeast Frontier Administration of Justice Regulation 1945 applicable in the state of Arunachal Pradesh will give way to the provisions of Civil Courts Act to the extent of inconsistency in relation to functioning of courts manned by members of cadres of judicial service. 33. We further hold that CPC and CRPC are applicable to the regularly constituted civil and criminal courts without in any manner affecting operation of Article 371A or the functioning of village customary or any other courts other than the regularly constituted civil and criminal courts in the state of Nagaland manned by members of judicial service. We further make it clear that this order will not affect validity of any orders already passed without following the provisions of CPC or CRPC on understanding that the CPC and CRPC were not applicable to the state of Nagaland. We also made it clear that the state of Nagaland will be at liberty to approach this court for any clarification before the next day. This will not affect the power of the state under proviso to section 1(2) of the CRPC and 1(3) of CPC to issue an appropriate clarificatory notification or enacting its own Civil Courts Act. So therefore, the application of the customary laws is already protected. So that is not an issue here. Let the government enforce chapter 4A because now in 2022, the village courts has already been constituted. However, that is not very clear. the extent of the jurisdiction of the village court. Whether it is confined to customary laws in the nature of, in the civil nature, or whether that includes criminal side also, that has not been clarified. So that part in future, there'll be a confusion. The second point is, in terms of Chapter 4A, the subordinate district customary court does not have appellate jurisdiction. But in 2022 notification in the Gazette, while enacting the village council as village court, now in that they have included that appeal from the decision of the village court lies to subordinate district customary court. Where we don't, as of now, we don't have subordinate district customary court. We don't have district customary court. And under Chapter 4A, subordinate district customary court has no appellate jurisdiction. Those things, we are not against it. We are not against it. The question here is, now, after the judgment in the case of Registrar General, by implication, the rule also goes. Then how do we file an appeal under Rule 31 of the repealed rules? To file an appeal before the executive courts. And if we are to follow that, then we will have two parallel courts. One is the regularly constituted courts where CPC is applied in letters, and on the executive side, CPC will be applied in spirit. They'll be inconsistent. They'll be inconsistent. And I believe it is not the intention of the court rendering the decision in the case of Registrar General that there has to be two parallel courts, one applying the CPC in letters and the other courts applying the CPC in spirit. That cannot be the intention of the court. And it stands repealed. Rule has stand repealed going by this decision. Although, as our learned AG knows better, now the domain of the application of CPC lies with the state. And also, the application of Civil Courts Act, it is also lies with the state. And the court can, the state can issue a notification for application of CPC as well as Civil Courts Act to the state of Nagaland. But here it is just the reverse. The court has applied the CPC, and now the state is not barred from issuing a notification under clause 1.3 of the CPC, 1.2 of the CPC. That part is not correct. Whatever it is, the court, your lordships, have to consider the peculiar circumstances. Now, in the case of Arunachal Pradesh, they have only the executive. Then in 2006, sometime, as per the judgment, they have created the judicial service rules. Nagaland also created 2006 judicial service rules. But before creation of the judicial service rules, now since 1984, steps have already been taken for separation of the judicial from the executive. And ADC includes ADC judicial, DC judicial. who are legally trained persons who are law graduates since 84. And after the creation of this judicial post as ADC judicial, DC judicial, now they continue to derive their powers and functions under the rules till 2013, till this judgment came up. And when these Registrar General orders came up, now they refused to entertain appeals from the village court, from the village councils, GBs or DBs. Their impression is that we have to go under Rule 31. But how can that be? And subsequently, the designation of ADCJ, DCJ has been, the nomenclature has been changed to District Assistant Judge, Additional District Assistant Judge. That is only a change of nomenclature. And from the time the ADC Judicial and DC Judicial was included in the definition of DC and ADC executives. Now, after that, the control of the appointment came under the purview of the administrative control of the high courts. But the appointing authority is the state. Appointing authority is the state. And even after the change of the nomenclature from ADC or DC judicial to District Assistant Judge, Additional District Assistant Judge, they continue to exercise their powers under the rules. Because only the spirit of CPC applies. And in fact, under the amended rules, now under Rule 24, new Rule 24.1, this is 1984 amendment. How, page 31, how do we file a claim? This also is given. This is in terms of CPC. This is in terms of CPC. And as I submitted, the chiefs, the Ganburas, the Mazadars, the village authorities, they are civil courts, not customary courts. A distinction has to be made there. Because what is a customary court? We find in the general definitions, page 1, on the general definitions. In these rules, unless the context otherwise requires, customary courts means and includes village court, subordinate district customary courts, and district customary courts constituted under Chapter 4A of the rules. So this courts comes under customary courts. The rest are not customary courts. Even before this amendment, the village courts, GBs, chiefs, Mazadars, they existed as civil courts. Therefore, to say that or to presume that a decision of a civil court, an appeal from the decision of a civil court cannot be filed in a regularly constituted court, that will be a stumbling block to the procedure. This is a kind of procedure. And therefore, even if till this chapter 4 is made applicable, now we cannot go under the rules for filing of appeals because that has already been repealed now. But in the peculiar circumstances of the situation, peculiar circumstances, that is the ground reality, appeals have to go towards the regularly constituted courts, as has been done in the past for many years. Nobody has been found aggrieved by that procedure. And therefore here, the constitution of course under chapter 4A, now it is with the state. We are not against it. But it will not be fair and proper on the parts of the litigants or for the litigants to await the outcome of that constitution of the village courts and then keep the pending cases in abeyance. That will not be in the interest of justice. As said by the Supreme Court, procedure is a handmaid. It is a handmaid. It is not a tyrant. So in this case also, the decisions of the decisions in the case of Registrar General should not be a tyrant. It must be a handmaid so that the litigants unnecessarily does not suffer. That is our concern now. Our concern is not how to constitute the customary courts, how to protect customary courts. It's already protected. We are not against it. Let the state enforce chapter 4A and make amendments whatsoever. We are not against it. We are not against 371A. But how do you solve the present remedy? What is the remedy of the present problem of filing appeals from the village courts, from the Dubashis, from the Ganguras? In which court do we file appeal? That is our problem now. And for that, a reference has been made. Now the reference has clearly started chapter 4A. And its view was that because of that, appeal cannot be filed in the district court, district and session court. In that case, the party is compelled to go under Rule 31. Now, if you go to the decision of the Registrar General, the rule has already been repealed.
Mr. Ralo, you talk about some reference. What is that reference?
Reference?
Reference has been made, you said. What is that?
Yes, Your Lordship. Reference has been made from his case.
See,
and
okay.
We have a similar case pending, so that was clubbed together. And reference, he may, but he'll explain better.
Which case?
Lordship, in Civil Division 5, order dated 8/4/2022.
Oh, there are two cases,
Yes,
5 and 6.
yes.
You are for 5.
I'm for 5.
Mr. Ralo is for 6. I was not there in the last court date, so I have limited understanding to this case. There was a case filed before the village court.
Lordship, against the decision passed by the village authority, we have approached the district judge Dimapur. Lordship, the district judge Dimapur is failed to exercise his power under Rule 31.
Under Rule 31?
Lordship, under the 1937 rules.
No, district judge is to exercise powers under Rule 31.
Lordship, Lordship, in the year 2008, the judicial officers in the state. Earlier, they were the deputy ADC judicials. Now their nomenclature has been changed to district instant judge and additional district instant judge in the year 2008.
You have the Civil Codes Act.
No, Lordship, that is the problem. We
You don't have Civil Codes
No,
Act.
Lordship.
Then what has been referred to in this judgment of that Registrar General? Administrative Justice rules applicable in the state of Nagaland. That means the 1937 rules.
1937 rules.
And the any frontier administration justice rule 45 applicable in state of Arunachal Pradesh will give way to the provisions of the Civil Codes Act. Which Civil Codes Act?
We don't have the Civil Codes Act.
You don't have that.
We don't know. Is it referring to some Arunachal has Civil Codes Act? Yes. Refer to Nagaland also. Nagaland is mentioned. No longer apply. So the village council code also has, the village code also has direct power from the ruler. So how did he, in the first place, in the field of suit? The very inception of the suit is for the village code, whether it's authorized or not. This is what I'm wondering. As per the provision, there's no limit, particular limit, any amount can be paid. Over many figures. It's very strange. We had this kind of thing in the last time. They had the limited, the pure limit was there.
Yeah.
Beyond that, there's
Your Lordships, if based on the judgment in the case of Registrar General, if the rule is repealed by implication, even in the case of Nagaland, then the powers of Mazadar, Gamburas, DBs, everything is gone. But the problem was in the case of Nagaland, it was not made clear. And the litigants, many of them are ignorant. And to go to approach the village level courts like Gambura, like chiefs or village council. Mostly they don't prior to approaching those courts, they don't consult lawyers. And since there is no clear-cut direction in this Registrar General's case in respect of Nagaland, out of ignorance, they continue to approach the village court. Now, if the rule is repealed by virtue of this decision, then they have the power to exercise.
No, the para 32, now we don't have the Civil Courts Act.
Lordship.
Correct? Civil Courts Act, we don't have.
No, we don't have.
We don't have.
We don't have.
So para 32 says the Administration of Justice 1937 rules
Yes,
will give way to the Civil Courts Act.
yes,
Now, when there's no Civil Courts Act,
yes.
then this 37 will continue.
Your Lordship, 37 rules.
Yes. Yes.
If
Rules.
it's not there. Once it is there, then it will, transition is there.
Your Lordship,
Case for 32, para 32 of the Registrar General's case.
yes,
It says that the administration of justice rules applicable in the state of Nagaland, so and so, will give way to the provisions of the Civil Courts Act. to the extent of inconsistency in relation to functioning of courts meant by members of cadres of judicial services. Now, when we don't have the Civil Courts Act, then the issue of the 37 giving way to the Civil Courts Act does not arise.
Yes, that is one view.
That
Now-
and there may be some other views also.
Yes,
This is one view we're
now,
taking.
in that case,
Hmm.
since Nagaland does not have a Civil Courts Act, now the rule applies. In that case, the present rejection of appeals by the district and session judge and civil courts, junior, senior divisions is again not proper. That part has to be again clarified.
Appeal was preferred under what provision before the district judge?
In relation to function of both month and members of cadre of judicial service.
Yeah.
Mr. Iralu, appeal was preferred before the district judge under what provision of law?
Under Rule 31.
Huh?
Under Rule 31 of 1937.
Rule 31.
Yes, under Rule 31, it can be filed before
District judge.
district judge or his assistant to deceased.
Assistant to DC.
Yes, like a civil judge, junior, senior division, because that has been, nomenclature has been changed.
Appeal was rejected on the ground that in view of the Registrar General's case,
They refused to take.
Act
They
has been
refused.
repealed. Act has given way.
Because of Registrar General's case, they refused to entertain appeals from, under Rule 31 against the decision given by the lower courts like Gamburas, Blaze Council, etc.
Is this an isolated case or
No, there are several cases.
what happens to those cases?
Because of this, all are pending. It cannot proceed further. And if Your Lordship, Rule 30, I'm sorry, paragraph 32 of the decision in the Registrar General case. Let me read out again, Your Lordship. It is thus clear that if legislative intent is to bar applicability of CPC and CRPC to customary courts or courts manned by executive officers, the said bar cannot be held to be applicable to regular courts. This interpretation will be harmonious with the functioning of regular courts under the Civil Courts Act and also customary or executive courts under the Administration of Justice rules. Accordingly, we hold that the Bengal, Accra, and Assam Civil Courts Act 1887 is applicable to the state, to the district of Dima Hasao and Karbi Anglong in the state of Assam and in the states of Arunachal Pradesh and Nagaland. So, as per this decision, it has been made applicable again, not 1887. Yes.
1887.
Yes.
That is the problem now, Your Lordship. In fact, with all due respect.
So you cannot say that you don't have Civil Courts Act.
No, you can say.
Yes, in
This
fact,
has
we
been
cannot
made-
say.
This has been made applicable.
Yes. Albeit maybe not in an appropriate way. Because whatever central acts and rules and regulations or Assam regulations are applicable in the state of Nagaland, even prior to the 1962, the State Act, those acts and rules, regulations applicable to the state of Nagaland are clearly put down in Naga Code Volume 1. It does not include Civil Courts Act. It does not include Transfer of Property Act. That is up to the state. Whether we are to adopt this CCA or Transfer of Property Act, it is up to the state. But now here we have come to this. So now what is the way out? That is our dilemma. And since Your Lordship, in fact, Justice Serto is also of the same view that appeals from village courts or the Bashis or Gamburas, appeal can be filed before the decision session judge. Similarly, your Lordship has also passed a decision on the same line, that is from the decision of the Bashis, that appeal lies before the decision session judge. Unless a way is open, the litigants are suffering. It is only for the interest of the litigants. And therefore, in terms of the Registrar General's case, the rule stands repealed. If it stands repealed, the other courts have no jurisdiction to entertain any civil dispute, except by the village courts, by the village council constituted as village court by notification in 2022. That can be taken care of by the state government, because it is the duty of the state government how to go about with it. It is not the duty of the court, I believe. But a clarification is now required. Because if the rule is gone, due to ignorance, out of ignorance, litigants still approaches the Gamburas, the DPs, the village courts. And now in appeal, where do we go? Where do they go? Though they don't have the power to exercise adjudication, power of adjudication. Out of ignorance, they have exercised it. And rule is gone, we cannot go back to Rule 31. Unless a way is open for the litigants to approach the regular size of the court. This is a peculiar situation. It is peculiar from Arunachal Pradesh, Karbi Anglong, or any other northeast states where at one point of time this rule applies. Even Mizoram, it is different. The situation is different. Even Mizoram, your Lordship will know better in that case.
We have the Civil Codes Act.
Yes, your Lordship have already had it.
2005.
Long before. You're far more advanced. But the problem, even if when the rule was there, perhaps, I do not know, but at that point of time, your Lordship, Mizoram may not have a DC includes ADC judicial. ADC includes ADC judicial. Perhaps that was not there. Arunachal does not have that. Karbi Anglong, all these Dimasa Hasao, is not there.
We had the Administration of Justice rules, we call it in short.
Yes,
1937,
yes,
similar to like Nagaland only.
similarly,
Wherein the disputes were decided by the Deputy Commissioner and his assistants.
yes,
So they were deciding civil cases, they were
Yes.
deciding criminal cases.
yes,
But with the enactment of the Civil Codes Act, the transition was there.
yes.
Separation.
Let the learned AG have a look into this Registrar General's case vis-à-vis the rules of 1937. Then let him come back. Maybe today he's not in a position.
Your Lordship,
Do you have a copy of the Registrar General? You are muted, we can't hear you.
Please. I'm audible, madam.
Yes, yes.
The situation is not as bad as it's being portrayed by my learned friend. I do agree that there are certain inconsistencies. Now, as far as CPC is concerned or CRPC is concerned, you have to pass the test of Article 371A by a positive resolution by the Legislative Assembly of accepting these changes made by any central act. So the question of introducing them through the back door otherwise does not arise. We don't have to pass a resolution saying we don't admit it. Because 371A starts with a non-obstant clause which says notwithstanding anything contained in this constitution. So this is a separate position altogether. And even last year, the Supreme Court, in a matter involving our practices under 371A, has categorically held that 371A is supreme, it cannot be touched. When there was a meeting, my lord, in 2006 with the then Chief Justice and 3-4 other judges, I also happened to be present. There also a guarantee was given specifically by the then Chief Justice, I think it was Chief Justice Sudarshan Reddy, if you're allowed to recollect, that as far as customary practices are concerned, we are not going to touch it. It was on this assurance that the matters commenced and by way of a test, Dimapur was given. Now, even this para 31, which my learned friend has been using, well, we cannot say everything has vanished. Nothing has vanished. True, there are inconsistencies which can be connected in its right perspective. I'll just draw your lordship. I'm just reading it for the first time here. In 31, Mary, madam, para 31. I think minus 31, your lordships may be 32. It is thus clear that legislative. You'll also have about this judgment, Registrar General.
This one, Registrar General.
Your Lordships,
Anyway,
since learned
anyway,
AG is there, let me, for his sake, I don't know whether he's aware of that, enclosure 4, notification dated 28th December 2013. After the Registrar General's decision, the state government passed this, law department passed this. The government of Nagaland hereby notifies that the provisions for the rules for the administration of justice in Nagaland 1937, which empowers the deputy commissioner and the assistants under Rule 15, are still in force. Therefore, the powers invested by the rules are to be exercised concurrently by the deputy commissioner and his assistants, except in Dimapur, Mauza, where separation of judiciary from the executive has been affected. Now, this was perhaps brought to the notice of the court, and the court at the next page, enclosure 5, says in para 3, the government of Nagaland hereby notifies that the provisions for the rules Enclosure 5, Your Lordship. Subpara 3. The government of Nagaland hereby referring to the notification.
Quoted, it is quoted.
Yes, next paragraph, the said notification prima facie appears to be in violation of the decision of this court in WPC 5783/2006 and other batch of cases. In that view, registry to register a case and notice be directed to be issued to the government, Advocate Nagaland, and the case be posted in the next week. Now after this, Enclosure 6, by notification dated 28 May 2015, the notification of event number dated 20 December 2013, empowering the Deputy Commissioner and his assistants to exercise concurrent jurisdiction of administering justice under Rule 15 of the Rules for the Administration of Justice in Nagaland 1937 is hereby withdrawn with immediate effect. This shows there is already repealed. We cannot make a difference between the criminal part and then the civil part. Right. Yeah.
Yes, Leonard AG.
Yes, madam. As far as these annexures are concerned, I don't have a single annexure with me, but that can be collected. It's not an issue. Now, as far as the gist of this decision is concerned, the decision admits of coexistence of both customary and civil courts. That is the theme. Now, the only problem is, what are the types of customary courts? That will be decided not by the High Court. It will be decided by the customary practice. And according to this practice, it was decided that you will have first a village court, then a subordinate customary court, then a district customary court. The whole purpose in this whole issue is, where will the appeal lie? I think that is the basic crux of the case. Now, if we have a district customary court, then appeal will lie from the lower form, not to the district court, but to the district customary court. That is the main issue. That will be in consonance with the customary practices of the people. They don't want to put their head into the civil court straight away. Now, what is the remedy after the district customary court passes an order? That is an issue which is open. Normally, if no provision is made, then in terms of Article 226 and 227, it is the High Court which will come into the picture, not a civil court. Now, for examining all these things, my lord, and I also look into all these annexes which they have filed, it is not too complicated a matter, but it is, maybe we must take notice of the fact that various notifications were passed and a lot of confusion exists. It is precisely for this purpose, I had said right at the inception, that we are seized of the matter and we are trying to bring some type of rationality in this entire exercise, which will solve once and for all this appellate provision, etc., etc. It is not the customary court has disappeared or by process of these rules have been vanished, everything goes. No. There are enough provisions in all these acts to protect these institutions. I can delve in with it very exhaustively without much disturbance to any of these acts. That is why I said, since our consultation with the government and the various authorities are in progress, I'll be able to come out, or I won't say myself, all of us will be able to come out with a rational understanding of this and try to mitigate this problem. It's not an isolated case, not at all an isolated case. So therefore, we won't take too much time also. We are conscious of the fact that appeals are pending. We are conscious of the fact. But the only problem which we may generally contend is that if we take or slip in our decisions anywhere, that may lead to further controversies. We don't want that to happen. It's only for this that I'm seeking time. Otherwise, I can argue it straight away. It should happen that we slip somewhere and we are in the process of consultation.
No issue on that, and we are ready to give you time.
Right.
The only problem is para 32 of the Registrar General's case.
Right.
That has brought the Bengal Agra and Assam Civil Courts Act 1887 in operation in the state of Nagaland. This will have some.
We will examine this particularly. Particularly, we'll examine this.
Have you
That is,
a copy of the order or the judgment? Not, is it a judgment or order?
Judgment.
Judgment. No, actually, para 36 has list again also.
Lordship, this judgment is reported in 2013, 114 GFT.
Cannot be a judgment. Just with para 36.
This is for some clarification.
The last paragraph, my lord.
Para 32 is very important. You can have a look at that.
That is, we make it clear that this order is that one, or we further hold. I have a different edition of the judgment. So it begins with, my lord, this para. We further hold. Am I right?
No, just above that para.
It is thus clear that the legislative intent.
Correct.
That is the part.
I'll examine this thoroughly and I'll be able to establish that there is not much confusion.
Okay.
This has provided clear protection to customary courts.
How much time do you
Clear.
want?
To be fair to me, my lord, I would require 8 weeks because I want to sort this out once and for all. And as I mentioned earlier, this is not an adversarial litigation at all. We have to respect the customary courts, put it in its right place. And consequent to that, we are going ahead with all other things which are pending as far as separation of executive and judiciary is concerned. We want to stick to our time. And this is in process. This is not, I've examined many of these things. I've seen this judgment also, though in the judgment, my name is mentioned as Advocate General, but I was not there. Somebody else appeared in the matter, but that's not the issue. I've gone through it. And I will see with reference to para 31, just a minute, Mr. Hiralu, just a minute. So as far as this is concerned, we'll have a proper look at it. And I think I will be able to come out with a proper solution by which I don't think anybody can have any grievance. Give me some time, I will do it. In fact, that was the hurry of the government also to establish those institutions which were conceived according to various regulations and of which we have to go ahead with a real execution in a letter and spirit. We're doing that. We cannot ignore the customary courts at all. The people, because it's up to them to go ahead with it. We'll just go ahead with it.
Your Lordship, we are not adverse. Nobody is adverse to the creation of a customary court. The creation of a customary court, whether will it solve the present problem? That is the question. We are happy.
That will be solved.
If the government creates customary courts under Chapter 4A, we'll be too happy. But that is not going to solve our present problem. That is our concern. I hope Learned AG understood that one. We are not averse to creation of a customary courts. Let the government go ahead. But that is not going to solve our problem here. That is our concern.
Your problem is limited to the appeal, if I'm not mistaken.
Yes.
Mr. Iralu? Yes.
Yes. But creation of customary court will not solve that in any manner.
He has clearly expressed, my learned friend, Mr. Iralu, that the issue is restricted to the appeals. As I was mentioning at the very inception, we'll find a solution to that, please. That's why I said it's not adversarial.
We'll give you 6 weeks, not 8 weeks.
7 weeks at least.
Heard, Mr.
Your Lordship, if AG could not be there on that next date,
Don't
again.
worry, I will not escape. I will be there.
Okay.
Heard, Mr. Limapang, Learned Council.
Don't say that about me. I will be there when necessary,
Division 5.
except for unforeseen contingencies.
As well as R. Ilaru, Learned Senior Counsel, assisted by Mr. L. Iralu, Learned Counsel for the appellant in Civil Division 6 of 2020. Learned Advocate General praised for some time to enable him to consider the issues raised in the present reference petition, as well as the implication of the directions passed by division bench of this court in the case of Registrar General of Gauhati High Court versus Union of India, reported in 2014 to GLR 379. Stop. Prayers allowed. List the matter after 6 weeks.
Can a date be fixed for the
Give a
convenience
date,
of
give a-
Learned AG?
okay. You want a date fixed?
Anytime after first week of August. We have Assam Nagaland border dispute in the first week.
7 August.
Or maybe after 15th. It's okay with a learned friend.
7th of August, is it convenient?
Till that date, we are having the Assam Nagaland border dispute. The cross-examination this is
14?
going on.
14?
14th will be, 14th is welcome.
List the matter, don't say after 6, list the matter on 14th August.
And if necessary, your lordship may even mention, as has been mentioned by my learned friend, the main issue is on the appellate provisions. That's what he has categorically expressed to me. If necessary, that can be borne in mind. We are also working on that.
Consider the issues raised in the present revision reference with regard to the appellate provisions.
That's it. Obliged.
For admission, item number 6.
May I please, Your Lordship? My Lord, in the file noting, it is not mentioned, but in the communication letter, it is stated between the Senior Superintendent of Police and the Special Secretary.
Who passed the detention order?
Special Secretary.
Special Secretary.
Yes, my Lord.
Page 27.
Let us see the files. 8th of 2023.
In the file noting, it is not recorded, my lord. That I flagged, my lord, in the letter.
Question. Where is located? Well, I believe that that's what it is. As per this provision. Communication to a person detained, 3 persons of the
Mr. Tipa,
Yes, my lord.
is this all the file that you have?
Yes, my lord. This is the record. And my lord, that letter which was forwarded by the superintendent, the next page, I flagged that one, that forwarding letter. Yes, only in the last paragraph it is mentioned that, yes.
See, issue is regarding compliance of subsection or subclause 3 of section 3.
Yes, my lord.
5 days.
Yes.
And at any rate, within 15 days.
Yes.
By recording reasons.
Yes.
We're looking for that. We just saw the proposal. Approval is given, thereafter detention. There's nothing which shows that communication was given to him. Is it there?
My lord, in the file noting, it is not mentioned.
No, that's why
Yes.
what we are trying to.
Yes. It is not mentioned.
We
my
want
lord.
to be very sure
Yes.
that this section 3(3) has not been violated by you.
Yes.
Once you violated, this entire thing will go. So we want you to be very sure. You can take some time, get the information from the special secretary, then come back. We can fix it up on Monday also, because most probably Wednesday may be a holiday because of the ULB elections. And the detention is expiring on 3rd of July. So we can fix it on Monday also. And you come back with the
Okay,
instructions.
my lord.
Just that
Monday,
part,
Monday.
Yeah. Maybe it's not a division day, division bench day, but then we can consider there's no issue. Okay.
Lordship, since the record is already placed before this honorable court, if you can consider and dispose of the matter today.
No, here there's only the, what you call,
Proposal and approval.
proposal and approval.
You only have shown us section 3, subsection 3.
Yes, your lordship.
We want to be sure whether they had there was any, whether there's any recording.
Beyond that, I don't think there'll be any recording because since the.
At least let him try to find out.
Let him find
Let
out.
us be sure.
In terms of this letter also, you can get some information.
Okay, okay, my lord.
But Mr.
Abi Senotsu.
Abi,
Yeah, Senotsu.
okay, you got the name for the petitioner. Mr. Tipapong, Governor.
Yes, my lord.
Governor advocate shall receive instructions as to whether the detaining authority, while issuing the detention order dated 4 July 2023, has proceeded in terms of the requirements met under section 3 within bracket 3 of the what act is this?
PIT and
PIT
NDPS Act.
NTPS Act 1988. PIT NTPS Act 1988. List
24.
as there's some urgency involved in the present writ petition. List the matter on 24th.
Much.
You take back.
Okay.